All right. How many things will I say in today's podcast that Hugh will make me edit out?
Oh, wow. That's going to be interesting. I don't think I've ever made you edit anything out.
I think you've strongly suggested that something be edited out once or
I think that
twice.
I may have taken something out of an early podcast after we talked about it one time, but I've never, it is what it is.
Right. Today is pro se all day. I kind of want to take some time to just talk about the pro se experience and some of the problems that people that are pro se, and that means representing themselves, they are acting as their own attorney, and some of the problems with just the rules rules is the wrong word, but just what's the word?
What do you mean rules are the wrong word?
Well, I mean, rules, because they're not the rules of procedure, family court procedure rules. They're not the rules of criminal procedure. Yeah.
You're talking about what the courts, the little rules that they, I say that in quotes too,
Yeah.
put in for their own individual courts. Yeah. So what Christine's referring to is the judges oftentimes, and we've mentioned it a few podcasts ago, will have rules it's usually about making objections or responses to motions or asking for a case to be called at motion hour if the judge is pre-ruling, which is sort of judge issues, generally the judge's office before each motion hour in Jefferson County, at least, and in some other counties will issue basically a docket sheet saying what's on the docket and what is likely going to be the ruling, or what the ruling's going to be. Either the case is going to be called for argument, or some things are pretty much perfunctory and this is going to be signed, or there's going to be, the other side gets 10 days to respond. It kind of tells you, and if you say, no, I don't agree with that, I want to be heard, you can ask the judge to call the case. But they have rules about, 10 minutes before court or 2 hours before court, you have to ask, and they all tend to be a little bit different. And
Which, being pro se, being an attorney, is difficult, and there's a ton to memorize, and we are trained to think a certain kind of way.
Oh, yeah.
People don't realize that in law school, you don't read statutes. You learn to think like a lawyer. You know what I mean? I always refer back to the statute, or back when I was a criminal attorney, every single case, I would print out what the client was charged with, or like in domestic violence case, I would print out the domestic violence statute, and that would be the top of my file when I was having a DVO hearing, because they got to prove XYZ, right? And so it's hard enough, but with a pro se litigant, they're supposed to be held to the same standard by the judge, but then, which is insane, because that would make our law degree worthless, right? If they were able to do it the same as us, in my opinion.
No, well, I agree. And I also think it's probably one of the most difficult things for a judge to navigate. I think it's, especially in a civil case that is so fact heavy as family court, because, and I know that the evidentiary rules are absolutely critical in criminal cases and in other types of family cases, but you're not likely to see as much coming in over the course of a case into evidence and as much testimony as you would see in an average family law case,
Right.
because you have multiple hearings and then a trial, possibly a trial. So there are so many different rules, and the judge having to navigate this person doesn't have an attorney. They clearly need to communicate something. It's definitely relevant to the case, but they're not doing it correctly. The judge has a role in not letting in evidence incorrectly, and holding them to the same standard, but also, if I'm sitting up there and I'm watching, I know what you're trying to do, but the way you need to say it is like this. I think that would be really difficult. And also, if you're up there and you have any sense of justice at all, you may technically be supposed to rule based on the preponderance of the evidence, and the other side got their stuff in and the pro se person didn't. But if
but you have a heart, right? So
you're a human.
Yeah. But most of the judges, you get a lot of stories where it's like, ha ha ha, you didn't get that in. They don't say ha ha ha, but the smirk is like, well, you didn't admit your evidence, because they don't realize that you have to be, Your Honor, may I move to exhibit blah blah blah. You know what I mean?
Oh yeah, when you're an attorney and you're supposed to be up to those rules, you'll have judges say, if someone at the end of the trial, oh, did I ever admit those? No, I was wondering if you were going to. And the judge will make a comment like that, and you realize, oh, the person never actually got that evidence into the record, and it can't be considered, and that's a big part of their case. I've seen young attorneys ask that question at the end of trial, and I've also seen some judges say, "Oh, yeah, let's go back on the record so you can put it on again."
Well, you can't do that first off. No, no,
No,
no.
no,
That's not,
no, but
especially for a lawyer. But also,
no, but I've seen them do it.
well, no doubt. But I mean, I don't know if they do it for pro se people. But so pro se litigants, it's extremely difficult to navigate. But that being said, we have a judge here in Louisville that actually was a former Commonwealth attorney that has made different rules for pro se litigants than attorneys.
Yeah, so in the past, I've commented on, you know, if each court has different rules about the conduct of their court, it makes it much harder for people that don't have an attorney.
Right.
And that's how are you supposed to know those things? Let's say you are a pro se person and you go and you get a statute book, you get a rules book, you commit them to memory, you do your research online, you ask the ChatGPT lawyer. None of those resources are going to tell you that this judge actually requires you to do this in their courtroom differently than all of the other courts.
Yeah.
And that happens to a certain extent at the county level. Certain counties require different filings and different things like that. But in Jefferson County especially, there are individual rules where each court does things differently. And I remember during the pandemic, we had
Oh my gosh,
the
what a mess
motion
that
hours.
was.
Some were on Zoom, some were on Teams, some were on phone. And yes, phone, where everyone was on a conference call together with no video, and it was impossible to know who it was speaking, except for when you heard the yelling, you knew exactly who that was.
Oh,
It's
Gina,
just-
we know you're having a cocktail right now listening.
Yeah, I hope so. But now, this is the first time I've seen a rule that on its face applies differently to attorneys and to pro se individuals. And I guess I didn't contemplate that might happen. So it was sort of shocking when I saw it. At first, I didn't recognize the significance of it. And then it just sort of hit me. It's like, oh, wait a second. Attorneys now in Division I are allowed to appear remotely without permission. But pro se, outside of motion hour, pro se people without attorneys have to ask permission at least 4 days in advance. Is that two?
48 hours, yeah.
48 hours, sorry. 48 hours in advance, or else they have to appear in person. Now, part of me, I get why for a court wanting to move forward and wanting things to run well, I completely understand. I have seen 15, 20 minutes of time be wasted because, oh, this person we expected to be there, they don't have an attorney, they're trying to log in. I see that happening. However, regardless of why you might want to do it and the fact that it might make it run more efficiently, I don't think you can't hold them to the same standard as attorneys, but allow attorneys more privileges in practicing in front of you.
Well, yeah, and also, this goes back to, I understand the notion of wanting to make things run more efficiently, but things will run more efficiently if you violate due process. Things will run more efficiently if you don't hear the evidence. They signed up for this job. That's what I just cannot wrap my head around. Not only did they sign up for the job, they ran for the job. They spent a shit ton of money trying to get the job, most of them. And they continue to re-up, LOL, on trying to get the job. But I don't understand why they think that they can get away with this other than the fact that they have just been able to get away with whatever they wanted to get away with for the last 10 years.
Yeah, I this is something that I've just seen, and I don't know what the motivation was behind it or whether there's a lot of thought put into it. But I will say my first reaction when I realized the significance of it was it went straight back to attorney advocate mode and thought, oh, wow. If I'm an attorney and I have someone that doesn't have an attorney on the other side, you could so take advantage of that.
They miss work.
So much of family law, and it stinks, and part of it is the inefficiency of the process. Part of it is the micromanaging of little details, but it becomes a war of attrition. And attorneys are there to win. And if it's winning by a war of attrition, that's what they're going to do for their clients. So if I have a way where I can just keep coming back to court, find legitimate reasons to come back to court, the other side has to actually physically be there and take off work, you're more likely to win that war of attrition. It makes it so much harder if you and your client can appear remotely because you're an attorney.
Right.
And the other side has to actually drive down there and park and wait for things to be called and actually take off work to do it.
And go in this big, scary courtroom. It's like, I'm not scared of a courthouse because that's my day to day. But you know how scared I am of an MRI? You know what I mean? Like, I don't want to do that. You put that off and off and off and off. You know what I mean? Or it's like, it's just, it's nonsensical. It's not an even playing field. And I told you this when we first started going. I'm like, there's going to be pushback, there's going to be retaliation, and they are going to quadruple down. And I don't want them to. It's disappointing to me that they do that. But this to me is in some regards just saying, like, we've got a problem with pro se litigants being on Zoom. You know what I mean? I can control them more when they're in my courtroom. And so they're nothing. They're peons. You know what I mean?
Yeah, I don't know that that's going on.
I know it is.
Okay. I mean, in this, I've never seen this division treat pro se as lesser than. In fact, this is one of the divisions I think that we complimented for bending over backwards and handling pro se's very different and making sure that their cases are being heard. So I don't know that I can read any of that into it. And I can also, so for practical reasons, let's say you're an attorney preparing for your hearing. You're going to go in there, but when you have an attorney on the other side, you find out if people are going to be appearing remotely or not. So if I'm going to prepare for a Zoom hearing or a person that's on Zoom, I'm going to have digital evidence that if they're sitting there on Zoom and I'm asking them questions, I can have them open something and go through it.
Do you hear yourself? I know where you're going with this.
No, I'm just...
Do you hear yourself?
What do you mean?
But you're basically just saying that you understand why, because the judge wants to give the attorney the advantage to know whether or not there's going to be digital evidence or in-person evidence.
Well, no, but if you show up and you can't present the evidence because someone is not there and they said they were going to be there and you can't put a document in front of them because they showed up remotely, it makes the whole thing run smooth. I'm simply saying that I see those motivations in this because those things were something that just frustrated. And if you have been waiting 3 months to have a 2-hour hearing and 30 minutes is taken up because of that, and you don't get to put your evidence on, and kids are waiting, there's stuff. I can see that. And I can see the practical reasons why someone would look at doing something like this, which I disagree with. You can't do this. More than that, some motivation to double down on something that we've talked about.
Well, I'm a goose gander type person. So what's good for the goose is good for the gander. So if I understand the notion, and I do agree that maybe 48 hours before a judge is going to conduct a hearing should know whether or not the parties are going to appear in person or via Zoom.
Yeah, just make it apply to the attorneys.
Exactly. Yeah, that's my point, because it's giving the attorneys an advantage because the attorney could decide last minute whether or not to come. And I don't necessarily believe that, like, Angela Johnson decided that and said that, I think that pro se people are peons. I believe that the system as a whole, if you have money in family court, you're a cash cow. And if you are poor in family court, you are an inconvenience.
Maybe to some elements, like if you are an FOC or a custodial evaluator, GAL, and there is someone you're appointed on a case where someone has tons of money, I think that can be cash cow. When I represented wealthy people, I would more often than not, would try to play it down because I felt that you got some bias against people that earned more than the judges did.
Absolutely.
And you would see that. And that's human nature. I'm sorry. I think everybody as a person is like that. I'm not saying you can be that way as a judge, but it's human nature. The same way when you're sitting there talking about a jury and you're picking a jury, you're making assumptions and you're finding out what you can about the jurors to have an idea about what their lens is going to be looking at your client in your case. You do the same thing with the judges as a practitioner. And if I had a client who was making 6 times what a judge did and not working very much, that was part of the consideration, and how we portrayed that in the case was important to me.
Oh,
so
absolutely.
I don't know that I see that.
But judges should be held to a higher standard than jurors, and I do think that's a problem. And no question. If y'all don't understand, and we talk a lot about pro se people, and that's kind of how we started this dialogue. But a lot of the people that are persecuted, if that's the right word, in family court, are the people that make a ton of money. And it's kind of like the first time they've ever really been persecuted in their life. And it's because they make so much more than the judge. Like, truly, like, and so in family court, they have to do a financial disclosure, and you got to disclose everything. And we can get all of the credit card information and all that stuff. And, we've represented people that's just, they buy a new iPad 5 times a year, 6 times a year. That's like nothing. Like, it's just like their kids do it. Do you know what I mean? And these judges, for the most, while they run for office, obviously they don't drive foreign cars, but because you won't get elected, that's another diatribe there. But, a lot of them can't afford a Mercedes. I mean, there's one sitting family court judge right now that tried to apply for a Mercedes and did not qualify.
Well, I mean, that's none of my business, but
It's
I
none of my
when
business
I
either.
look at yeah, when I looked at clients, it was absolutely what I found was that, and people tend to look at people that make more money than them. Doesn't matter what level you're on. You look at what your cost of your living is, and you assume that that's all that they need to pay for. So everything else above that is just gravy. And you would find that, well, there's all this disposable stuff, and it would sometimes ignore the actual list of expenses and
Yeah,
the
yeah, yeah.
standard of living that the parties actually did, and they have more money going out than coming in, even though they have high incomes. And I just always prepared my clients for that, but it's sort of, yeah,
No, it is
it's a
none of
totally
my
different issue.
business as far as, and that's why I didn't mention the judge's name. And I have no interest whatsoever in talking about the judge's private life, their drinking habits, their partying habits, any of that kind of stuff. That's none of my business. And y'all keep sending it to me, but I don't want it. But my point is as an attorney, you do have to prepare your
Oh yeah,
clients for that kind of stuff because it does
yeah,
matter. Like you have to understand, that you're super upset about a car and the judges can't afford that car. That was kind of my whole point. And we started this on pro se and the differences between that. But I think it just goes back to the fundamental problem that family court is an equal opportunity masochist.
that's there's another T-shirt.
I try.
That would be a good one. Yeah, I think that's right. But I mean, back to your idea. I mean, the simple solution to the Division One rule is make it apply to attorneys.
Hmm.
It's not that the efficiency motive is incorrect. Like if that's going to make things run more smoothly, it's going to mean as an attorney, I get to go in there. I know whether the person's going to be in there or not, whether they have an attorney or not. I know what kind of evidence I need to bring, and we're not going to have to sit there and wait for someone's Zoom to fail or something to happen because we don't know how. They're just
Yeah.
there are lots of issues that might solve, but it has to apply to both sides. And that's the simplest solution is usually the correct one. I overlooked that, and you nailed it.
Well, it's like, and I just think that these judges need to put themselves, I mean, empathy is a real emotion that I don't know that they understand. But I think that'll be what makes our app so good too with this community feature because you have to understand there are certain things that you have to do in each division. And us as litigators got to know our judges. We got to know what made them happy. We
Yeah,
got to know what made them angry. We got to know what made them throw things and run off the bench. And so when you're pro se, you don't have that frame of reference to know that, oh my gosh, if I say the words due process, you know what I mean? I'm going to go to jail. Like that's not on their radar, right?
yeah, no, that's true. But I also don't think that that's a possibility in a lot of the divisions. And
Yeah, for sure.
Division One in particular, I
No.
never found there was a lack of empathy or attempts at empathy. And I saw,
On
I,
the scale, for sure.
yeah, and I've definitely seen more patience with people who are pushing the buttons and trying to. I've seen people representing themselves in there that think they're smarter than everyone else, that are accusing the judge of things that any other court I wouldn't have ever let it push that far. And she's been very, very patient in trying to be empathetic.
I don't
Actually more so than any other that I've seen. So
and you had a lot of cases in her division.
I did.
I didn't have many. I never mind having hearings in front of her. I didn't like being in front of her for motion hour. I didn't like that at all. It wasn't a motion hour.
Hmm.
I just never knew what I was going to expect. You know what I mean? Don't get me wrong. She never was cruel or any of that stuff. Like, we're not talking Brian Gatewood level or any of that. But I just wasn't my preference, where there were certain divisions I knew exactly what to expect with what was happening. And
That's how I felt there. It was always like you knew what you were coming into. It wasn't like, oh, what mood or like what's going to happen.
yeah,
I
it's
liked Division Ones particularly for that. I had the exact opposite experience.
And again, this goes back to why Judgy's going to be so amazing because Hugh is going to rate the judges completely different than I'm going to rate the judges. Some
Yeah,
of his
that's
favorite
true.
judges, I'm like, have you lost your mind?
No,
And I'm like, this one doesn't bother me. And he's like, this person's a monster. Do you know what
well,
I'm saying?
one of the things I enjoyed, and I've always enjoyed judges who if I challenge them and I'm advocating and they think that I'm wrong and I push back hard, it isn't personal and they're going to push back, but it's just you're arguing hard for your client and
Yeah.
it doesn't get personal. I have always enjoyed that.
Yeah.
And I
I do. I
always
miss having more men judges as well. Yeah,
Oh,
that's
no,
I
I
miss
always
that.
felt that in Division 1. That was one of the things I could go and I knew I was going to argue. And the one thing I couldn't figure out, some divisions, you're going to lose if you go in and argue something. Never knew that.
Yeah.
I thought each case I didn't know.
Mhm.
And that's kind of how I feel it should be. Like,
Yeah.
I shouldn't know what the outcome's going to be on the motions that I go in. I think it should be considered. And I never felt like I was rushed and didn't have, if there was
Well,
anything that was painful in that is she gave people a lot more opportunity to argue at motion hour than most judges would. And if you're waiting to go to another one, you may have to sit through a lot of crap, but I took advantage of that. And
let's piecemeal this a little
yeah,
bit. So, for example, you should know, legally speaking, and if I'm wrong, tell me I'm wrong. But legally speaking,
you know what the law is.
well, you have to have for temporary maintenance, right? You have to have a hearing. Am I wrong?
Oh, no. That's
No, but
absolutely
I'm
right.
just, am I wrong?
No, you're
Okay.
not wrong.
So temporary maintenance, if someone files a motion for temporary maintenance, the court has to have a hearing before making a determination. Is that an accurate statement?
Yes.
Okay. Well, why don't they understand that?
I agree. And in fact, I used to see it more than I saw with the current batch of judges. It's been far less than a problem than I encountered with the prior, which was
We just
a
saw
little
it.
surprise. No, I agree, but I mean, it used to be you'd get full-on maintenance orders and they'd be called temporary maintenance orders from motion hour, and it was just you
But
can't
you,
you
you,
absolutely can't do that. Now it's usually a little more nuanced, or one particular judge just does whatever she wants and puts temporary on it. But I wouldn't expect that to be called. So I'm talking about things
they call,
that
yeah.
need to be called and argued. You're
And
not going to argue if you only have temporary maintenance on. It's to get a hearing date. That's the appropriate thing. The judge shouldn't be taking arguments on that. You're just going to get a hearing. Honestly, in my opinion, wasting everyone's time if you're calling up there and letting people say their piece to just give them a hearing anyway.
But do they know that? I don't know that they all know that. I mean, we've seen judges allow that to be argued. And that just goes back
That
to
depends on the division.
but two pro se people wouldn't know that they have to, or one pro se person up against an attorney wouldn't know that there has to be a hearing. And if the judge doesn't know that's the law, you know what I mean? It's just a good way to get railroaded. And I think that it needs to, this goes back to, I think, episode 42, where we talk about we need public defenders. You shouldn't have to walk into a courtroom when your constitutionally protected rights are at stake without an attorney.
Yeah, but how does that happen if, let's say, because we've talked about that in a recent podcast, and we're talking about specifically the constitutionally protected right to parent your kids. But if you're in just a property divorce, rules like this that treat attorneys and pro se individuals differently, it could have a huge effect financially. It could cut someone out of, lifelong retirement,
Mhm.
vital health insurance benefits. I
Mhm.
mean, there are just lots of little things like an attorney might want to just go ahead and have a decree entered early because they have to wait too long, judge, for this hearing. And the pro se person, if they don't know to appear, that could have huge effects on their health insurance, retirement, things like that, and they wouldn't know.
Yeah.
But you're not probably invoking a right there that would
Yeah.
amount to a public defender type
I
person.
personally do struggle for the appointment of an attorney in a divorce without children, because I'm trying to find the constitutional right at stake there. Now, I'm open to the conversation.
Sure. No, I agree with you. I'm just saying that these rules
Mhm.
have effects on
You're
people
right.
that wouldn't be able to have appointed attorney.
So, y'all, do you know how many comments? Hugh doesn't know. He doesn't read a single comment unless I screenshot it and send it to him.
Well, I
And
don't have to because you screenshot every damn one of them and send it to me.
and sometimes I was about to say, like, you probably wake up in the morning and have like 47.
Yeah, I read the ones you send.
But y'all are obsessed with his facial expressions.
Oh, God.
Literally. And so if you're listening, you have to go watch on YouTube to see, because he does do really good facial expressions. And I try to like match sometimes, but and he does it in court too. And he did that when he was a litigator.
Oh, yeah.
Y'all. I mean, he
I know.
really did. Like, and he would like turn around because we'd have like we'd all be sitting in the bay and he would turn around. You could tell he was so mad. But anyways, well, we appreciate you guys so much. It is judge-y.com. Judgy, the app is so close. It will be here before the end of 2025. Thank y'all.
Yeah. Thank you. Bye.
We need some justice, justice. My life is fine, justice.
Content of this podcast is for informational and entertainment purposes only. It is not intended to be and should not be construed as legal advice. Engaging with this content does not create an attorney-client relationship between you and the hosts, guests, or their firms. The views and opinions expressed on this podcast are solely those of the individuals involved and do not necessarily reflect the official policy or position of any law firm, company, or organization. We make no representations or warranties regarding the accuracy, completeness, or applicability of the information presented. Any reliance on the information in this podcast is at your own risk. Laws are constantly changing, and every situation is unique. You should always seek the advice of a qualified attorney for your specific legal concerns.